Good afternoon. I'm Melanie Corey, Meetings Coordinator of SCNRA. Today, I would like to welcome you to our webinar presentation, Improving Your Bear Rental Agreements, with John Parker, Corporate Counsel for NBAS, and Tyrone Silva, also Risk Manager, also for NBAS. This webinar is brought to you today by SCNRA in partnership with KHL. We would also like to take a moment to thank our May sponsor, Hayes Companies. All attendees' phones are in listen-only mode at this time. I encourage you to submit questions during or after the webinar presentation on the chat sidebar, which is located on the bottom of your screen in the little chat box. We will answer as many questions as possible at the end of the webinar. This webinar is being recorded, so all attendees will be emailed a link to the recording along with a brief survey after the webinar. Please take time to complete the survey so that SCNRA can improve our webinar offerings in the future. At this time, I would like to introduce today's speakers, John Parker and Tyrone Silva, who will present today's webinar on improving your bear rental agreements.
Good afternoon, everyone. Thank you for your time today and allowing us some of your time to talk about improving your bear rentals agreements. One of the things we want to talk about first is obviously your contracts and how that works to protect you guys with respects to claims and accidents, and obviously transferring some of that risk over to the party that's at fault or the party who has signed off on your rental agreement. So are you protected for all that could go wrong? I like to say the best defense is a good offense. I relate the analogy to football. This may ruffle a little feathers here, but I'm a New England Patriots fan, and I think they're one of the great teams that clearly show that, you know, in order to win ball games, you have to have a good offense in place, and that offense obviously helps the defense out to win the game. With that being said, I want to talk about an accident that occurred down in Florida where we had one of our contracts in place. So the first line of your defense is actually going to be your contract language. The Florida accident that I wanted to refer to is the one where, let me back up just a bit here. We have what we call a man-crane situation. And so I know this is a bear rental conversation that we're having or webinar that we're having, but the same contracted risk transfer principles apply in both the manned and the bear rental situation. So for this accident here, we got a 6-story parking garage collapse. And I'm going to try to walk through this with you also. If you can bear with me, there's a lot of facts that play into this particular claim, but at the end of this, you'll be able to see how the contract came into play and was able to help us transfer some of that risk over to the at-fault party, but also actually get us out of the case without paying any money. So here's what we got. We got a 6-story parking garage collapse. We have 4 fatalities, 7 people injured, 2 people left with brain injury. Damages are in the millions. We got 11 named defendants, 15 insurers, and over 100 participants in the mediation. And it took it actually took 4 mediations total to settle out all these claims. Now, the crane company that we did insure was a named defendant in 5 cases, 4 of those cases being wrongful death cases. I'm going to try to tell you about the facts first, and then we'll get into damages, and then I'll talk about how the contract played a crucial role in getting us out of it. So, again, it's an accident with a man rental. We have our crane company, which we insure, who is hired by a prefab concrete company to assist with the erection of this new parking garage. The crane company's job in this particular contract is to lift these large concrete spandrels so that they can be secured to the concrete columns that support the garage. Now, I'm not sure if many of you are familiar with concrete spandrels, but they're basically a concrete panel that's used as a exterior veneer to cover the concrete floor trusses, okay? Now, at the time of the accident, our operator is basically making these picks or lifting these concrete spandrels in the blind. He's relying on the signals of the lift director, which in this case, the concrete prefab company is both the lift director as well as the signal person. So they're giving the crane operator instructions where to pick it up, where to swing it, where to put it down. The accident occurs on a Wednesday. However, the crane company had been on site for 2 days prior to the accident, and prior to that accident, they had already made 6 successful picks. So you got a situation where we're doing well for the first couple of days. On the third day, an accident occurs. And just bear with me with regards to the facts, they're pretty long here. So we got 6 successful picks. And at the time of this particular accident, okay, the crane is actually sitting idle. We have a spandrel on hook. The operator is sitting there idle, waiting for the connectors to secure the spandrel to one of the columns located on each side of the structure. So we have a load, if you follow me, we have a load that's approximately 70 feet in the air. It's held in place so the prefab folks can secure it to the columns. And in the midst of the prefab folks trying to secure that spandrel, 4 of the bays within this concrete structure collapse. All 6 stories come down in the center of the structure, unfortunately killing 4 workers, injuring 7, and causing 2 of those parties to end up with brain damage. Here's the catch. At the time of the accident, the crane is not moving. It's not in motion. When the dust finally settles, the crane is not moved. It's still sitting there, holding this concrete spandrel in the air, as it was prior to the accident. So there's nothing here to show that the crane operator or the operation of the crane had any causing factor in causing this garage to collapse. Like any accident, an investigation commences. There's multiple forensic experts on site, structural engineers on site, OSHA is on site. Everyone is basically out there. After discovery, we find later that 2 days prior to the accident, so we got the accident on a Wednesday, on Monday, the boom of the crane had actually struck one of the concrete columns. Okay? The facts of that incident supported that the operator was signaled by the signalman to boom down. And when he did boom down, he had a 50,000-pound load on the hook. So it brushes against the concrete column, but it doesn't cause any damage to the structure itself. The column is then slightly repaired, if you will. They have the general contractor, a structural engineer, and the prefab company come out to take a look at this concrete column. They give it a thumbs up. They say that it's still in plumb. They do something with the fasteners to try to straighten those things out, but there's nothing significant to indicate that the column has to be fully replaced. So after that investigation ends, they go back to work. Once they go back to work, the construction site is ongoing. On Wednesday is when the accident occurs. Again, there's experts on site, structural engineers on site, OSHA is on site. No one can show any causation from the operation of the crane causing this collapse. And in the end, they actually proved that, again, no causative factor by the crane to cause this collapse. They proved that there was a structural defect in the design of this particular garage that actually caused this garage to collapse. In the end, we got damages, 11 defendants, 15 insurers, 100 participants in the mediation, four mediations total. Total damages, $40.5 million. And in this instance, our crane company is one of the deep pocket insurers that's involved in this litigation. And as we all know, I've been a claims adjuster for 8 years prior to coming into this risk management role. We all know that the plaintiff attorney is going to go after the insurers with the deep pockets. So unfortunately, our crane company is one of those individuals. And as I said prior to talking about this particular act, or during this accident, we had a contract in place, okay? That contract provided that the prefab company would provide indemnity to the crane company that to such a point that if the prefab company did anything wrong, okay, they would be responsible for it. If the crane company did anything wrong, they would be responsible for that. So pretty much a partial indemnity clause, if you will. But again, there are no facts to actually prove that the crane company had done anything wrong in here. So with all that being said, we got these damages. We ended up paying no money in this particular claim, zero, just nada. And the reason why is we successfully tendered the claim over to the insurer of the prefab company on the grounds that we had this contractual indemnity provision that said that the prefab company would indemnify the crane company for what they've done wrong. We also had an insurance provision within that contract with the prefab company that required the prefab company to provide additional insured status to the crane company. Those key provisions are critical. And that's some of the conversation that we're going to talk about today, is having that right language in your contract to be able to transfer the risk over to the party that is leasing your crane. Again, $0 paid on this particular claim. We were able to acquire additional insured status from the insurer for the prefab company, and they were able to reimburse us for our defense cost. Reason being, we had a contractual provision that required additional insured status. I can tell you from a claims perspective, if you don't have an indemnity provision that's going to protect you, you're in trouble. If you don't have an additional insured provision, you're in trouble. So with that being said, let me bring you to 7 key provisions that you want to have in your contract. And the reason that we put this Florida case up there is to give you a good example of when you have the right contractual terms in place, you're more likely to have better arguments to make, number one, but it could possibly be the difference maker in getting you out of a case or even keeping you in a case. So we got 7 key provisions that you want to have in your contract. First provision you want to have, indemnification. What is that? We're basically shifting liability from one party to another. That's what we had in the contract with the prefab company. That's what was able to allow us to transfer that risk back over to the prefab company and have the court rule in favor of us because of a provision. You want to have an additional insured requirement within your contract, okay? That additional insured requirement should have language to the effect that the crane user, who is obviously renting your crane, is agreeing and is promising to provide you guys with additional insured status. Now, I do have one issue with this, and I've seen this in my claims experience. Let's say you go out there and you got your customer, the crane user, to sign off on your agreement that has an additional insured trigger. Okay, they sign off on it. They give you a certificate of insurance, but they never went back to their broker to have you endorsed on their policy as an additional insured. The problem with that is when the claim comes in, the insurer is going to take the position that, okay, my insured agreed to the terms of this contract, but as an insurer, I have no obligation to provide you with additional insured status. This is a contract between you and my insured. It's not between you and the insurer. So if you're relying on a certificate of insurance, that's not a good thing to rely on. It's only evidence of insurance. It doesn't convey insurance to you as the crane owner. So you want to go a step beyond just getting a certificate of insurance. You do want to ask your customer for a copy of an additional insured endorsement, which shows that you were endorsed onto the policy of that customer. Another provision that you want to have in your bear rent agreement is physical damage coverage for your equipment. We know that you're renting this equipment to this customer with the trust that they're going to do the right thing, that they're going to run the machine correctly, that they're going to have a competent operator operating the equipment, that they're going to service the equipment while it's in their possession. But what happens if they damage your equipment? That piece of equipment could be, who knows, $1 million, $2 million. It could be a $5 million piece of machinery. And if they don't have physical damages or risk coverage with sufficient limits to cover your equipment when they damage it, you're in trouble. You're in trouble because, one, your crane's down. Two, that's another crane out of service, so that hurts your business. So you certainly want to have in your contract that provision that requires your customer to have a inland marine all risk physical damage policy that will cover your particular crane to a replacement cost value. So you want an insurable replacement cost value. You do not want actual cash value. That's only the market value of the equipment. You want it at a replacement cost value. You want to have in your bear rent agreement a waiver of subrogation clause. You don't want to impede the rights of your insurer to go after the customer who is the crane user in this instance. You don't want to impede your insurer's rights to go after that particular party for recovery of the damages or even the replacement of the machine if it's damaged beyond reasonable repair. You want to have in your agreement the operational of equipment clause. This is critical, also an operational compliance clause. And I'll tell you why it's critical. If you got someone who's using your crane and they got some new hire guy on your crane, running your crane, chances are that person's not going to have a lot of experience and they may possibly ruin your machine. So I would strongly recommend that you have a clause in your contract that says something to the effect that the crane user is agreeing to hire someone who is competent, someone who is experienced to run the machine in accordance with the ANSI regulations and the B30 regulations. You want to have a borrowed servant argument or clause within your agreement as well. And I'll tell you why. There are situations where, and you guys probably encountered this, you are renting your crane out on a bare rent basis, but you get a last minute change order. And now they're asking you to furnish an operator to run the crane. Well, the borrowed servant argument is going to help you in a situation where if something goes wrong, where the operator does something wrong or the signal person signals the operator in the wrong capacity, an accident entails, the borrowed servant argument will argue that, one, the crane operator is now an employee of the crane user. The crane operator is now under the jurisdiction and supervision of that crane user. So having that provision in your particular contract is critical. You want to have a provision for B30 arguments. You want to have the provision for the B30 argument to make the argument that the responsibilities of the parties are going to be in accordance with what the B30 shows in their standards. Many times you have the lift director directing the crane. Their signal man is giving signals to the crane operator, and an accident can occur. Immediately, the first thing they're going to do is most likely say that it was the fault of the crane operator. Okay, well, the B30 spells out the responsibilities. If the crane operator is waiting on a signal from the signalman and the signalman gives the wrong signal, then now we have an accident. That's not necessarily the fault of the crane operator. It's the fault of the signal person. And when you have those B30 regulations in place and you have a clause in your contract to say that we're going to follow by or we're going to be in accordance with the B30 regulations, you can make some legal arguments as to the responsibilities of the parties. You want to have a provision in your contract that speaks to the OSHA regs with regards to qualified signal person, qualified rigger. You want to have a qualified lift director or site supervisor, and those two people can be the same person in situations. So you certainly want to have some language in your contract that will refer to OSHA regs. You want to have a provision for ground conditions. I always recommend that you insert language to address who's responsible for the ground conditions, soil conditions, as well as the support capability of the crane. Usually you have a situation where the site supervisor is responsible for the ground conditions and soil conditions, but also there can be some responsibility on the operator to ensure that where he set up the crane has the right ground capability. So there's a dual responsibility there. But by putting a provision in your contract that says that the crane user is going to be responsible for the ground conditions, you are thereby protecting yourself in the event of a claim. And let's say you set up on poor soil conditions and the crane starts to lift a load or something like that, and the weight shifts, the crane shifts downward, you have an accident that comes into play. If you had that provision in your contract, well, now we have an argument to transfer some of this risk back over to the crane user because their site supervisor is responsible for the ground conditions, but while at the same time, we're trying to mitigate some of the risk that's going to be apportioned to the crane operator because ultimately he or she set up there as well. You want to have a provision in your contract for power lines. You want to make sure that the crane user is keeping the crane away from power lines, that they have a responsibility to have the power lines de-energized in the event that the crane is going to move too close to those power lines. There are regulations in place with regards to voltage, and we all know that there's a certain amount of proximity that you can be in, but in the event that, the boom of the crane gets close to a power line, you could have some arcing there. So you certainly want to have a provision in your contract with regards to power lines. With regards to rigging, you want to insert into your contract language that holds the crane user responsible to provide the rigging, and that crane user assumes the responsibility for any defects in their rigging. I've seen it time and time again where, even in a bare situation, you'll have someone injured on a job site, or you'll have some property damage, and immediately the claimant, they file a claim against the crane company. And in this instance, the crane company may not even be on site. It's a bare rented situation. You're an off-site equipment provider, but you got a claimant who's filing a claim against you because you have the biggest machine out there and the machine was being run at the time of the accident. So you certainly want to have some provisions in there with regards to rigging to give yourself some protection there. I've seen it time and time again because it's the biggest machine out there, it's easily visible. The first party that gets sued most of the time is the crane company, even when you're not at fault. Obviously, if you have a contract in place with these provisions that we're talking about, you give your insurer some talking points, you give your insurer some arguments to make to try to get you out of the case, or at the very least, mitigate some of the damages. You want to have in your contract a provision for LMI. We don't want the crane operator to rely solely on the LMI that's in a machine. Those indicators, that indicator was only used for the purpose as an aid only. It should not be used to replace the operator's experience and or knowledge. So you want to have that provision in there that says, that has language to the effect that the LMI should only be used as an aid only, not to replace the crane operator's experience and or knowledge. Certainly put a provision in for that. And my last point here, in terms of key provisions, you want to have a provision for authorized signature. Again, and forgive me if I talk a lot about claims. I'm a former claims adjuster. I'm passionate about this. My dad's a crane operator. He's been a crane operator for 37 years. My brother's a crane operator. He's been an operator for 17 years. So I'm certainly passionate about this, and I don't want to ramble on about it, but being a claims adjuster, I've seen a lot. I've dealt with a lot of these claims. I know how litigation can get very ugly if you don't have the right contractual provisions in place. So authorized signature is probably one of the top things on my list, and it's critical. I've seen it time and time again. You have a contract where you rented out your crane. The crane user does not sign off on the contract, or they have someone who's not authorized to sign off on the contract. An accident occurs with that crane. Claimant turns around, sues the crane company immediately, and then we come down to the point that, well, someone signed the crane ticket, but that individual who signed was not an authorized representative or didn't have the authority to sign the agreement. What do we do then? Well, chances are, if that person didn't have the authority to sign the agreement, it could possibly, on a technical issue, be an invalid contract. Or it's going to be difficult for your insurer to try to argue the terms and conditions of the contract, because if I'm a plaintiff attorney, I'm going to argue, well, the person who signed was not authorized by my company or by my client to sign off on that particular contract, or they didn't have knowledge of the terms and conditions. Either one of those arguments can go far in a court of law. So you certainly want to have a provision for authorized signature, and something to the effect that the person that's signing the agreement has been given authority to sign the agreement on behalf of the crane user. I want to talk about indemnity insurance and operations provisions. And I know I've touched on some of these, but I wanted to give you guys some examples rather than just ramble on about what you should have. I wanted to provide you all some examples of just some standard indemnification clauses that can help you out. So I'm going to take a look at this first one here. Basically, it says the lessee agrees to release, indemnify, save lessor, its officers, its agents, and employees harmless from claims for death or injury to persons, including the lessor's employees. That is terrific, because you can have a situation where they're only indemnifying the crane operator, the crane company, and not the crane operator. It also says you should indemnify for all loss, damage, or injury to property, including the equipment, arising out of any manner of the lessee, and in this case, I'm going to substitute lessee with crane user. So arising out of any manner out of the crane user's operations. However, the crane user should not be required to indemnify the lessor against any liability for damages arising out of the bodily injury to persons or damage to property caused by or resulting from the negligence of the lessor or the lessor's agents or employees. That's a pretty good indemnity clause. It's partial indemnity, so it's fair, number one, because if it's not fair, most likely the customer, the crane user, is not going to want to sign your contract. They may not even give you the job if you don't have a fair indemnity provision. So I would say that what you need is you want a favorable indemnity provision that's favorable to you as a crane company, but it also got to be fair enough to get you on the job and allow you to go to work. The insurance provision. This is a standard insurance provision. It says leasee agrees, crane user, I'm going to use in this instance, my apologies. Crane user agrees to provide and maintain minimum coverage set forth in this section. Crane user shall carry and maintain inland marine all risk physical damage insurance coverage to cover the full insurance value of the equipment. That's that language that I was speaking of earlier, where you want to make sure your customer, the crane user, has sufficient physical damages coverage to cover your equipment if they damage it or even damage it beyond repair. So that's what that provision is speaking to right there. But also, you want to have coverage that's also going to cover the boom and the jib as well. You want to have this provision that I've been speaking of with regards to additional insured coverage. This one reads as follows. Lessee shall name the lessor as an additional insured on all liability policies. You don't want just the primary insurance. You want to include both excess and umbrella policies. All policies should be endorsed with a waiver of subrogation in favor of the lessee. So here we go. We got the additional insured provision in there to give you guys, the crane owners, additional insured coverage, which also includes a defense. That's important because you don't want just indemnity. You want insurance coverage and the defense that comes with it. So when you get this additional insured provision from your customer, that entitles you to all the coverages that are available under the policy, but also available to the named insured. So that certainly has to be in your contract. It's very critical. The next provision here, operation of equipment. We've talked about that. You want to have someone who is both competent and experienced to operate the equipment. Again, there are situations, and you all seen them, where you go, it's a bear rent at one moment. Next thing, the customer calls you, well, we need an operator to run the crane. My operators are all out on other jobs. Can you supply an operator? Okay, if you got this language in there, okay, that brings in that borrowed servant document that we were talking about, where now that the crane operator, even though he may be still on your payroll, okay, he's still under the, contractually, he's under the supervision and jurisdiction of the crane user now. That's your borrowed servant argument, so you want to have that in there. The next paragraph here, competent and experienced personnel to direct the operation of the equipment in accordance with the OSHA reg for signal persons. Again, you want to make sure the person that is signaling the crane operator is qualified according to the OSHA reg. You can have anybody out there that is not so great at signaling. You have a provision here with respects to the responsibilities will be in accordance with the American National Standard Institute. That's the ANSI, as well as the B30. B30.5 2014 is going to be used when operating the equipment. That ties back to what I was speaking of earlier with the B30, where you now, if you have that language in your contract, you help your insurer to make legal arguments with regards to the responsibilities of the parties on the job site. So every contract, you want to have reference to the B30, reference to the OSHA reg here for signal persons, but also a reference to the OSHA regs as well, 1926-1400. Lastly here, you got the lessee or the crane user. You want to have a provision that says the crane user agrees to use the equipment in accordance with the manufacturer instructions. How many times does that happen? You got a guy out there who's just running it the way he wants to run it. A claim happens, and the first thing the plaintiff attorney is going to say is, well, did you follow the manufacturer specs for running that particular piece of equipment? No, I was running it this way and I did it that way and I've done this for 30 years. Well, that's not going to hold up in court. So you certainly want to have some language in your contract to protect you on that end. I'm going to move over to ground conditions and power lines. I touched on this a little bit, but you want to have a provision again for ground conditions. You want to have that language, inserting language that says who's going to be responsible for it. In this instance, it's a bare rent, so you want to have the crane user responsible for that, for those ground conditions and soil conditions. Again, the operator ultimately sets up on the ground, but according to the B30, the site supervisor, who would be most likely the customer, the crane user in this instance, it's probably their personnel that's supervising the operation of the crane, but also providing a signal man. You want to have these provisions in place. Again, power lines, we talked about that. You don't want to have the crane set up too close to power lines, and if they are, it's going to be the responsibility of the crane user who's actually using your crane at that time. They should have the responsibility to de-energize the lines if anything should go wrong, because again, you got a crane, you got a boom up in the air next to a energized power line. I've seen it before where you get some arcing, runs right down the boom because it's metal, and now you got injuries or you got property damages. Again, rigging here, you want to have a provision there for the crane user being responsible for the rigging. They're responsible for any defects in rigging, but also the crane user is responsible for the method of rigging, but also they agree that the person who is providing the rigging is qualified, or even supervising the rigging is qualified according to the OSHA reg. I'm going to move on to LMI and authorized signature. Touched on this a bit here, and I do apologize if we're going over the screens too slowly here. But again, no reliance on load measuring device. It's an aid only. It should be used as an aid only. The operator should not rely on it to replace his or her knowledge or experience. Authorized signature, we talked about that. If you don't have someone who's been authorized by the company that's renting the crane, if any Joe Blow just signs off on it, there is a potential argument that that person was not authorized to sign the contract, gives you problems in litigation. And I'm going to move over here, and I'm going to have John Parker take over here, and he's going to speak to you about indemnity.
Okay, thanks, Tyrone. This is John Parker. I'm corporate counsel with NBIS. I work with Tyrone in reviewing a number of our insurance contracts, and also work with the claims folks in handling claims and litigation. Just a little legal 101 on what indemnity is all about, and it's basically a promise by one person or entity, who we call the indemnitor, that it will indemnify or make good a loss for damage incurred by another party, or a claim made against another party, who we call the indemnity. So if you're giving indemnity, you're the indemnitor. If you're receiving indemnity, you're the indemnity. You can have a duty to indemnify arising basically in legal contract interpretation in three ways: an express contract provision, which is what we're all about today, having that express indemnity provision in the contract; an implied contract provision, for example, where a party agrees to be responsible for certain aspects of the performance of the contract, and the court reads into that an implied indemnity obligation. Or you can have what's called equitable indemnity, where by virtue of the roles of the parties in the performance of the contract, it's only fair that the one party handling a particular part of the performance provides indemnity for that part of the performance of the contract. You obviously do not want to rely on anything but an express contract provision, because the implied contract provision indemnity and equitable indemnity are basically a crapshoot when you go in front of the court. So under general negligence law, as a general rule, each party is liable for its own negligent conduct. And where both parties in the performance of a contract have some fault or some negligence, then they're both liable according to the degree of their negligence in the accident or the act which led to the injury or damage. So what we have with our express indemnity provisions that Tyrone has touched on is basically shifting liability from one party to another. It's the whole basic fundamental aspect of risk transfer, which is what we want these contracts to be all about. Indemnity law is state specific. There's not a national indemnity law. And that's why we recommend multiple contracts depending on how many states you may operate in. Different states have different statutes which may limit the ability of an indemnitor to indemnify another party. Many states don't like an indemnitor being required to indemnify the other party for the other party's own negligence. So you want to make sure that your contract complies with the state law that applies to a particular job or a particular rental. All right, Tyrone, you want to give us that next one? Additional insured endorsements. These go hand in hand with indemnity provisions because what you may not be able to get through an indemnification provision, for example, where you have a state that limits how broad an indemnity provision can be, you can get through an additional insured endorsement. The states that don't want broad indemnity provisions in construction contracts, for example, are absolutely fine with insurance companies taking on that sort of indemnity, because that's exactly what an insurance policy, a liability insurance policy is. It indemnifies the insured for the insured's own negligence or claimed negligence if an accident occurs. So you'll find any number of states, and some of them even have it specifically in their indemnity statute, that says the fact that we're going to limit the amount of indemnity you can give or receive has no effect on the ability to insure or to have additional insured endorsements. So that's the importance of these, where you may be limited in how much indemnity you can give or receive. The additional insured provisions of the policy for your crane rental company and your crane user comes into play, and so that's the vital importance of having an additional insured endorsement, whereby you as the crane company have the additional insured status with the crane user's insurance company. Okay, Tyrone, I think we're ready for the next one. This is kind of what you see here on the screen is a standard daily rental contract that a number of our insureds use and that we recommend. And then you'll see some of the basic provisions on the front that recites what the equipment is, recites who the parties are, what the effective date of the contract is, and so forth. So in your terms and conditions, you're going to want provisions that deal with the effective date. What's the effective date of the contract and when does it end? Delivery, how delivery is going to be affected and who's responsible for any damage to the crane during the delivery process. Job site conditions, ground conditions, power lines, rigging. Tyrone has covered that. Scope of work. What's the what basically is going to be the performance of the contract. No reliance on the LMI. Tyrone has touched on that. Indemnification. You've seen that language. The insurance. This is where you have the insurance that the crane user must provide, and also includes the references to being made an additional insured. Limitations of liability. That is to say, what you as the crane rental company agree to be liable for, and what the crane user is liable for. Choice of law, dispute resolution. Choice of law means what state law applies. So you'll need a provision in there that will designate the state law that you want to apply. It's usually the law of the state in which your business is located. dispute resolution? Do you want an arbitration clause so that you have mandatory arbitration as opposed to conventional litigation? Severability, that means that if a court in reviewing the contract holds that certain parts of it are void, then that means that that's severable, though that part of it is severed out from the contract and the rest of the contract is valid. And then the entire agreement, that means that you want this written document to be the entire agreement between the parties, and that there's no oral modifications or anything that was said before it was signed modify the agreement in any way. In other words, what you're looking at is the entire agreement between the parties. Okay, Tyrone?
Hey, John, I want to touch on this real quickly.
Sure.
On this daily rental contract, where it talks about having signed at the start of the job. Oftentimes on a manned rental, you may run into a situation where your operator arrives on site, 5:30, 6 a.m. in the morning. He gets out there and the customer's not there. And he wants to get set up for the operation, but there's no one there to sign the crane ticket. So finally, parties arrive, and now they're in a rush to get the crane set up and get going with the work. But unfortunately, the crane ticket is still not signed. I can tell you 9 times out of 10, if you don't have this crane ticket signed, it's like having no contract at all. If we don't get it signed, we cannot bind the parties to the terms and conditions. That means we cannot fight for you. We can fight, but we can't do our best to fight, I should say. It really ties our hands as an insurer to try to protect you when we can't argue the terms and conditions of your contract because we have no signature. So I would encourage anyone on a daily crane rental situation, make sure your operators get the ticket signed. It's going to come down to a business decision. I don't know what your company policy is with regards to getting job tickets signed, whether this guy even starts to work or not. But if you don't have it signed, most likely you're going to have some trouble down the road.
Absolutely. The Florida case is a prime textbook example of the benefit of foresight rather than the benefit of hindsight, because had that contract not been in place, it would have changed everything for the crane company in that situation. And so the moral of the story is never let anybody rush you into proceeding with the work before the contract is signed.
Sure, and I can tell you this, if you get an accident, no one's going to sign the job ticket. I don't think anyone's going to want to sign if an accident occurs. So it's definitely critical that your operators get this contract signed as soon as the job begins. Use of the right contracts. John, you want me to touch on this?
Yes, please do. Go ahead.
All right. When you're renting daily, let's start here. When you have a manned crane or whether you have a bear rent crane, obviously you want to make sure you have the right contract in place. If it's a manned agreement, the terms that we provide on a manned agreement are pretty similar to what's in your bear agreement. It's that standard indemnity, that standard additional insured provision. You have those in your contract, so that way we can protect you. So you want to make sure you have the right contract for the job. But touching on what John said earlier, you want to make sure that you have the state-specific indemnity. If you have multiple contracts, let's say you're operating in multiple locations, and you got one job. Let's say you got one job in Texas, and then you got another job that you got to do over in Houston. Not Houston, that's in Texas. You got one job in Texas and you got another job in Oklahoma. And you got a crane rental ticket that you're trying to use at the Oklahoma location. Well, chances are the indemnity provisions that are available, that are allowable in Texas, may not be allowable in Oklahoma and vice versa. So you want to make sure that your crane operators are going out the door with the right crane tickets, or even when you're doing bear rental, agreements, you want to make sure that the indemnity provision is state specific. It's the right contract for the right job. John, you want to do this slide?
Sure. This is a listing of some other contracts that you may come to use in the course of your business. This is a little bit beyond the Bear Crane rental agreement, but these are the various kinds of contracts that we look at every day, and that we emphasize to the insureds that they need to have these various provisions that we've talked about in the operated and manned rentals, the Bear rental, the warehousing, if you're keeping something on your yard for a customer, the carrier agreement for transportation, and then the subcontractor hold harmless agreement if you're going to subcontract out some of the provisions of your own contract, if you're going to have another contractor come in and do some of the work that you're contracted to do. Again, as Tyrone said, they're state specific. You need to make sure that the indemnity provisions comply with the applicable state law, and of course the additional insured requirements need to be in every policy so that insurance company who has you as an additional insured has an obligation to defend you. Tyrone, I think we can go to the next one.
Sure.
And this just goes back to what we've said. Cross those T's and dot those I's before there's an accident, because as Tyrone said, once an accident happens, ain't nobody signing a contract. That's not real life. And what you do by making sure that you have the contract in place and that you have the signature on it before the work begins is that it puts your company first in the line of protection for both defense and indemnity. And so that's what these contracts are all about. It's just best business practices. It's mitigates your risk, reduces your exposure, and ultimately protects your bottom line. I think we can go to the next one, Tyrone, and the questions and comments.
Got it.
Perfect. Okay, well, thank you, John and Tyrone, for that wonderful presentation. At this time, we are going to go ahead and Q&A portion of the webinar. And if anyone has any questions that need to be asked that haven't been submitted already, you can do so in the chat sidebar, which is located in the bottom right-hand side of your screen. But I'm going to go ahead with the first question, which is, how do we handle a last-minute change order on a Bear rent wherein the customer asks the crane company to supply an operator?
Yeah, and I'll answer this, John. It goes back to something that I was talking about throughout the presentation here. This comes down to a situation where it's going to be you want to have a provision in your contract that addresses the area of the right to control. It's a last-minute change order. Initially, it was a Bear rent. Now they're asking you to to supply an operator. If you don't have some language in your contract with regards to who's in control of this borrowed employee, you're certainly going to set yourself up for some liability if in the event there is an accident. So again, you want to insert a provision that deals with right of control, has a borrowed servant argument in it that says that the operator, although he is now working or although he is now a borrowed employee of the crane user, who is the lessee in this situation, he is now under that crane user's supervision, jurisdiction, and responsibility.
Perfect. So our next question is, do you have samples of the various leases that we can look at?
Yes, we do. Yes, we do. We actually, NBIS, one of our risk services that we do is when you become an insured with NBIS, we take a look at your existing contracts. We look at the provisions that you have in them. we look to see whether you have those 7 key provisions that we talked about in this presentation. And if you don't have them, then we obviously make recommendations to get them placed in there. But we do have some sample contract language that we can provide.
Okay. And our next question is, our business is located near the state line. So some of our crane rentals are to job sites in a neighboring state. Which state law would apply to our contract in this situation?
John, you want to
take that one, Tyrone? Yeah. Typically, if there's no provision in the contract as to what the governing law is, choice of law takes effect, and this is a whole esoteric area of the law whereby the court who's reviewing a contract decides which state law applies in a multi-state situation. And typically, if it's not provided for in the contract, the basic rule of application is that the law where the contract is to be performed, where the making of the contract is, applies. So in those situations where the project is located is likely to be the state law that's going to be held to apply to the contract. You can avoid that by having a governing law provision in your contract which says this contract shall be governed by the law of blank, wherever your choice may be, and typically you'll want it to be in the state in which your business is actually located. But failing that, that's how choice of law applies. It's generally where the contract is made, and that's typically at the job site, at the project site.
Okay. And our final question is, what do we do on a manned crane rental when the customer's authorization rep isn't around to sign the job ticket at the start of the job? Yet, when the authorized rep finally arrives on site, the operator is being compelled to expedite the crane setup, which leaves no time to get the job ticket signed.
Yeah, and I'll answer that, John. That goes back to something that I was alluding to earlier, where you have to have someone sign the contract who has been given authority to execute the contract. If it's just someone that's a lay person on the project and they sign off, there's a potential argument that will be made by a plaintiff attorney in litigation that individual did not have authority to sign the agreement. So how could he or she agree to the terms and conditions of the contract? Again, this is a situation where it comes down to what the company policy is. Do you have you as a company talk to your operators about these situations? It happens often. You get out there, and again, it's early in the morning, and you're trying to get set up. No one's there, and what do you do when they're compelling you to set up quick and get the job started? And it makes for a tough position for the crane operator, because A, do I start working without the contract being signed, or B, do I leave the job? And if I leave the job, how does my employer respond? I don't want to end up down the hall next week in the unemployment line, So it comes down to a company policy, and operators are faced with this on a daily basis. Whether to sign whether to start work without getting the ticket signed, or just walking off the job. And you're in a tough spot as an operator, when you got to make that decision, because you think it's easy to, walk away, but then, how is your employer going to respond if you didn't do this big job? You could possibly end up down the union hall looking for work. I've seen it time and time. I've heard my dad, I've heard my brother talk about it. It happens. And unfortunately, the operator's in a tough situation. So it really comes down to a company policy, a business decision on the company, whether you want to go to work or not, without the ticket being signed. I've already talked about it earlier. If you don't got it signed, it's like no contract was in place in the first place. And it's a lot of high risk if you don't have anything to protect yourself. And that alludes back to what I said earlier, is your contract is your first line of defense. It's your front line. You have to have it in place, and you have to have it signed.
And we actually just got another question that was submitted, so I'm going to go ahead and ask that one as well. Other than the contract, what paperwork is recommended to before crane is bear rented? And then in parentheses, it has inspections / certification of operator / manuals.
What paper, the question was what paperwork is recommended, Melanie?
Yeah, other than just the contract.
Yeah, well, if it's a bare rent situation, most likely the crane user is going to want the inspection records. They're gonna want to know, what maintenance has been done on the crane, because honestly, once that crane goes out bare rent to the crane user, okay, they are now technically responsible for the maintenance of that crane while it's in their possession. It's actually in the B30 where the crane user, there's a standard in the B30 where the crane user now has the responsibility to maintain and repair that machine when it's in their use, or in their custody, I should say. So with regards to what agreements or what documents should be in place, most likely the crane user is going to request a copy of the inspection records. I believe that's probably going to be the biggest piece.
Okay, and it looks like this was also a two-part question. Can all of these items be translated to bear rentals on hoist and man lifts?
You got some different situations, but I can tell you this: the indemnity, yes. The additional insured provision, yes. The operation section is going to have to be modified so that it fits the lift versus a bare rent situation, a bare rent mobile crane situation. So again, you have to have some modifications to the operation section, but the indemnity and the additional insured provisions are pretty much the same. You want to be additionally insured by the customer, and you want indemnity flowing from the customer to you as the crane owner.
Okay. And it looks like we might have already kind of touched on this, but I have another one in here that says, what if the contractor leaves before the end of the project? We can't get the ticket signed. So we kind of already touched on that.
Yeah, let me ask you this, Melanie. Was the tickets, okay, so the contractor leaves before the ticket is signed. Did they sign it at the beginning of the day, or they just didn't sign it at the end of the day?
It just says, and we can't get the ticket signed.
Yeah, in that situation, if you don't have a signed contract, you have no contract at all.
Okay, and then I just actually got a message, and it says yes at the beginning, no at the end.
Okay, that's fine, because here's what you've done. You got the ticket signed at the beginning, so you effectively, you got the customer bound to the terms and conditions. They signed off. It's one of those situations, let the buyer beware. So if they sign the contract at the beginning of the job, and your contract says something to the effect that this is the signature of the person who is signing this agreement is a authorized representative on behalf of the company who is renting it, then you have effectively gotten that party to agree to the terms and conditions, whether they signed it at the end of the job or not.
Perfect. Okay, so it looks like all of the questions have been answered at this time. And obviously, if anybody else has any questions, they can reach out, I'm sure, to John and Tyrone, and they will be able to assist you guys as well. And you can also reach out to me. We would also like to thank everyone for attending the webinar session today. And of course, thank you to our speakers for their expertise on this topic. As previously stated, all attendees are going to receive an email along with a recording of today's webinar and a brief survey. And then, like I said again, if anyone has any questions, please don't hesitate to contact me after the webinar. The phone number is 703-698-0291. Thank you, everyone, and thank you, John and Tyrone.
Thank you, everyone.
Sure thing.